Tēnā koutou katoa. Welcome everybody to tonight's webinar. I'm Nicola Batossi, General Manager of Multiple Sclerosis Auckland, and it's my absolute pleasure to welcome you here this evening for our information webinar. MS Auckland exists to support, inform and advocate for anybody who's impacted by MS, and this is one of our really popular information programs. So the format of tonight's session, which will be recorded, is going to be an informal webinar presentation, and the presenters welcome your questions as they're speaking. So please type them into the Q&A box and they'll be answered live on screen. We do ask that the questions are of a general nature, so if you have a question that's really specific and unlikely to apply to anybody else who's watching tonight, we ask that you might hold that. But otherwise, the presenters have requested that you ask everything, and no question is too silly. So please ask away. This would be a wonderful topic to hear about tonight. So without further ado, I'm really pleased to welcome joining us on screen from Hesketh in Auckland City. We have Alison Maelzer, who is a partner. We also have Matthew Morrissey, who's part of Alison's team. They live and breathe this kind of work. They're employment specialists, so we know that this is a really big issue, big questions held by a lot of people with MS, and we're really delighted to hear some expert opinion and guidance on this tonight. So please fire your questions through as they come to mind, and I will now hand over to our speakers, Matthew and Alison.
Thank you, Nicola. Thank you for that. Welcome, everyone. Thank you for inviting us along this evening. So the idea of this evening's session is to really give you all a little bit of guidance on some employment law topics that we think could be relevant to people living with MS. We've got quite a lot to cover. We're not sure if we're going to get to all of it. It probably depends a little bit on how many questions and how much conversation we have. But honestly, the questions and the conversation are just so valuable. And I think, if you're sitting there thinking, I've got a question, there's a very good chance that somebody else in the room has got that same question as well. So please do make sure that you ask any questions that you have. So what we're going to cover today, we're going to have a real sort of potpourri of employment law topics. We're going to have a wee look at the Human Rights Act. We're going to have a look at the Privacy Act. We're going to have a look at some employer obligations, so things around what you should be looking for in an employment agreement, some information about sick leave, flexible work arrangements, health and safety, and I guess sort of worst case scenario if someone is trying to have employment terminated for incapacities, for medical incapacity. We will hopefully have some time at the end for discussion and questions, but as Nicola said, fire those through as we go. And I think, while you think about a question, that's a really good time to answer it. You might have forgotten that by the time you get to the end. I know that's what happens to me. So please do fire through any questions that you've got, and we'll try and answer those as we go along, assuming we can make the technology work. So looking at the Human Rights Act 1993, as you'd probably be aware, the way that the Human Rights Act works is that it's essentially got a list of what they call prohibited grounds of discrimination. And that covers all the usual suspects, so things that you might not be allowed to discriminate on the basis of, so age, sex, family status, race, and of course disability is one of those prohibited grounds of discrimination. So disability is defined quite widely in the Human Rights Act. So you'll see up on the screen there, it can be physical disability or impairment. It can be a physical or psychiatric illness. There's a sort of, I guess, a real catch-all in the bottom left corner there, any other loss or abnormality of psychological, physiological, or anatomical structure or functions. So that really covers quite a broad range of disabilities. And another sort of angle, I suppose, of potential disability is reliance on some form of remedial assistance. So be that a wheelchair or a guide dog or an oxygen tank or some other item or assistance that a person might require in order to continue operating. And so the way the Human Rights Act works is that you've got these prohibited grounds of discrimination, and they apply in certain areas of life, basically. So one of the grounds is access to public service. There's provisions for not discriminating in education, in housing, various different areas of life, one of which is employment. So under the Human Rights Act, it's unlawful to refuse or omit to employ somebody on the basis of one of the prohibited grounds of discrimination. It's unlawful to give somebody less favourable terms, so to pay them less or to give them fewer hours or less KiwiSaver contributions on the basis of one of the prohibited grounds. And of course, it's unlawful to terminate someone's employment. So you can't fire somebody because they
diagnosed recently, for example.
Have been diagnosed recently, or any of the other, of course, prohibited grounds of discrimination as well.
And that covers also the whole range and the gamut of sort of working arrangements. So it's not just employment, but it can also be for if you're an independent contractor, certain volunteer relationships as well. So it's not just if you are an employee-employer as well. And just touching on what Alison said as well, the less favourable terms can also extend to certain things that don't necessarily go top of mind. So it can even include things like redundancy compensation or health and safety rules as well. So it's generally anything that you might be able to agree or disagree on with an employer.
Yeah, so I guess it's unlawful to do any of those things on the basis that somebody has a disability. It's also unlawful to have a form, so an application form, or to ask questions at an interview that indicates that you're intending to discriminate on those grounds. So if you're asking questions about somebody's medical status and that those questions aren't linked to the person's job, then that's potentially indicating an intention to discriminate. Similarly, advertisements. So if I put an ad up on Seek saying only people under 50 may apply, clearly that's going to be something that's indicating that I'm intending to discriminate against people on the basis of age. I guess the possibility of somebody having an advertisement that required able-bodied people or a certain level of physical fitness could potentially be something that ran afoul of the Human Rights Act. It would really have to depend very heavily on what the actual job was. So if there was no reason why a person needed a reasonable level of physical fitness, my job, for example, doesn't require much physical fitness at all. If the ad was saying that I needed to be physically fit and actually I don't really, then that's possibly going to be indicating an intention to discriminate. So one of the questions that we do get asked really often is about whether employers can actually ask that question. And I guess we advise both employers and employees. So if I was talking to an employer, what I would say is that you should only really ask questions if, first of all, they relate directly to the role that you're employing for. And secondly, if you actually really need to know that information. So you need to have a little bit of a think as an employer about, actually, do I really need to know that? Is that really important for the role that I'm recruiting for? And if the answer is no, you shouldn't even be asking the question. So hopefully that kind of makes sense. Shouldn't hopefully be too many surprises in that. There are a few exceptions that are sort of carved out in the Human Rights Act in relation to disability. And so again, this all applies to employment, the employment sphere. So one of those exceptions is where the particular position that you're talking about could only really be done by that employee with the aid of special services or facilities, and it's not reasonable to expect the employer to provide those services or facilities. So if, for example, somebody was used a wheelchair and the particular workplace was not wheelchair friendly and didn't have access for employees in wheelchairs, then it would depend on all the circumstances as to whether it was going to be reasonable to expect the employer to make the workplace wheelchair friendly. And I guess it's kind of the difference between your Fonterras or your BNZs or your large corporate employers. It's almost certainly going to be reasonable to expect Fonterra to make sure that people who are using mobility aids such as wheelchairs are going to be able to access the premises. If you're talking about your sort of local corner dairy being run by mum and dad, it's probably not necessarily going to be reasonable to expect special facilities that might be quite expensive to enable somebody who's using a wheelchair to be able to take that job. The other exception is where in a particular work environment, it would be dangerous essentially for the person with the disability to be carrying out that particular role. So you might have for example, a workplace which requires working at height could be a dangerous situation for somebody who has limited mobility. The carve out there at the second part of that bullet point though, again, is if it would be reasonable for the employer to take steps to reduce that risk, to make it safe for the person with the disability, then again, the employer is expected to do that. I guess it's unfortunately there's no kind of really hard and fast rules in this stuff, and employment is really quite prone to that, to be honest. There's a lot of it depends.
Yeah, our favourite answer is always it depends, which unfortunately doesn't necessarily give you guys the simple, clean answers, but it is always something that you're going to have to look at and think about.
Yeah, so thinking about the particular position, thinking about the particular employer, thinking about the particular circumstances and the adjustments that you're asking an employer to make. So this is kind of like the exception to the exception, if you like. It's a carve out of all of the exceptions. So if you've got a position where some of the duties of that role are not going to be possible for someone with a disability to do, but it would be easy for the employer to carve out those particular duties that are going to be a problem for the person with the disability and have those duties done by somebody else, then you're not going to be able to rely on the exception. So in my role, for example, generally speaking, I don't have to do anything that requires any particular mobility. There might be the odd time when I need to navigate some stairs, but honestly, my employer could adjust the position so that the stair taking could be done by Matt instead, and he could be the person who goes and gets me my coffee in the morning instead of me having to go and get it for myself. Yeah, so the questions just come through, and that very smart person has picked up on the typo in the previous slide where we've talked about the employee providing the services and facilities. That is a typo. It should be the employer who is expected to provide the facilities where that's reasonable. So good spotting. That was just checking that you're actually all reading the slides. So well done on that one. The other exception is kind of what we've called their positive discrimination. So this is kind of what I guess you'd call, or what some jurisdictions call affirmative action. So this is where you're discriminating, so you're treating people differently based on one of the grounds, the prohibited grounds in the Human Rights Act, but you're doing it for a good reason, right? You're doing it because you're trying to make sure that groups within society that need assistance to need a bit of a lift up to achieve an equal place, that's sort of you're taking those actions to help those people rather than to disadvantage them in some way. So examples of that might be situations where there's a particular program to help disabled people into employment or to provide occupational training for people with disabilities so that they can gain skills to enter the workforce. If I applied as a non-disabled person, I would be kicked out of that program, but I wouldn't have a claim under the Human Rights Act because the discrimination is being done for a good reason.
There also needs to be some sort of business case or link for why that positive discrimination needs to take place. So it isn't necessarily just a wall that an employer or an organisation can sort of hide behind. There does need to be some sort of link between why a certain group within society needs that assistance as well. So that is always something to consider if you're trying to take or you're trying to encourage an organisation to implement a positive discrimination or affirmative action within the company.
Right, so that was a whirlwind tour of the Human Rights Act. Moving on to the Privacy Act, we've got a new-ish Privacy Act. It came into force in 2020, so it's still new to me. The idea behind the new Privacy Act was kind of to really modernise it a bit. It was last amended in 1993, so that's getting on a while, and obviously we've had quite a few advances in technology and stuff since then. It's also supposed to try and give a bit more teeth to the Privacy Act, so to provide some consequences, I suppose, if employers or organisations breach the Privacy Act. Whether it's done that or not is probably up for debate, but that was the intention anyway, and it's a good intention. Right, so the Privacy Act, it kind of all hinges around this concept of personal information. And personal information is what we've put up there on the slide. It's information about an identifiable individual. So it doesn't need to be like super secret or sensitive information. It's all information about anyone who can be identified. In order to be an identifiable individual, their name doesn't have to necessarily be attached to it. So if I say the person who is wearing a stripy jersey in the employment law webinar, is paid $20 an hour, it's pretty clearly identifiable that that is going to be personal information about Matthew, even though I haven't said his name until now. So personal information can be contained in all sorts of places. So an employer will likely collect a whole bunch of personal information about you. They're probably going to collect personal information when you're recruited for the job. They're going to collect personal information in the form of your bank account details and your IID number. They're potentially going to collect information about your next of kin and your contact details. They might collect information about what you do for your job and how you do your job and whether you're doing a good job of your job. So there is a whole lot of different kind of types of information that an employer is likely to be collecting.
And it can also not just be words, but it can also be photos, videos. So a photocopy of your passport or your driver's license, for example, although not words, is collected by the personal information under the Act.
Yeah, it's a really, really broad definition. And also one of the questions that we get asked all the time is, what if it's just an opinion? So if I say Matthew is an idiot, is that personal information about Matthew? The answer is yes, it is. It is information, even though that's an opinion and not particularly detailed or accurate information about him. It is nonetheless information about an identifiable individual. Right, so the idea with the Privacy Act is that this personal information, there are 13 information privacy principles, or IPPs, that govern what you can do with someone's personal information. And I guess the first and starting point is that an agency or an organisation can only collect information for a lawful purpose. So if you're collecting information for an unlawful purpose, not only is that going to be unlawful in some other way, but it's also going to be a breach of the Privacy Act as well. So an example in an employment context would be if I'm collecting information about somebody's marital status or somebody's health status for the purpose of discriminating against them and deciding what to pay them or how to pay them less or whether to get rid of them, then that would obviously be not only a breach of a bunch of other things, it would also be a breach of the Privacy Act. You should collect personal information directly from the person it relates to. In most circumstances, there are some exceptions to that. And when you're collecting that personal information, you need to tell the person why you're collecting the information. You need to tell the person whether they have to provide it or not, what will happen if they don't provide it, and what use the agency is going to make of that information. So if you're collecting my marital status or information about my health or information about the treatment that I'm undergoing, I'm entitled to know why you want that information and what you're planning on doing with that information. So an employer who's collecting information in like a job interview situation, obviously they're collecting that information for the purpose of deciding whether or not you're able to do that job. If they go on and then use that information for something else entirely, that's going to be a problem under the Privacy Act.
And it's also going to be the same if they disclose it to any other organisation without your knowledge as well. So if they're passing it on to any related organisations or another client, or potentially even within the organisation as well. So if you disclose information to your HR, you then chase it elsewhere, that might be, again, a breach of the Privacy Act.
Yeah, and you do hear those stories from time to time of disgruntled HR people who share everyone's salary details with everyone in the company, or who leave information on the photocopier or whatever. So yeah, clearly going to be a pretty big problem in terms of the Privacy Act.
As well as individuals can also access their personal information So that's not just with your employer, but any organisation that collects your information. And you also have the right to ask for information to be updated or corrected. So, for example, if they've got your age and they've held that for several years and that's slightly out of date, or a more obvious example would be an email or your home address, for example, you might want to have that updated. Agencies also have a requirement to delete information that's no longer relevant for the purpose that they collected it. So a really easy answer is if I'm a candidate applying for a job and I flick through my CV and my cover letter, if I'm not successful in that position, it's sort of expected that the company or the agency delete or remove copies of that information. Or if I'm an ex-employee, they shouldn't really be holding on to my bank details or my IRD number.
Cool. Alrighty. So if you've made it past the Privacy Act and the Human Rights Act and you're still awake, employer obligations. So what should you be looking for when you get given an employment agreement? I guess the first thing that I would say is, unfortunately, you do need to read the employment agreement. Sometimes they can be quite lengthy and painful, but it is honestly worth reading it. It's worth asking for advice about it. If you have access to someone who has some knowledge of employment law matters or HR matters, it's worth running that employment agreement past them. The employment agreement is the whole basis of the employment relationship. So employers will, through either ignorance or maliciousness, try and put some weird stuff in employment agreements. Sometimes we see some real weird stuff.
Even when we think we've seen it all, there's some real curveballs there, and as well as just some certain things that just really cut across the law as well, which would really shock you. So generally, an employment agreement as well can sort of encourage and inform you of things like your leave entitlements as well. So making sure that those are all right.
It's a really good plan at the start of the employment relationship. So another thing that you want to just check for when you get a new employment agreement is to see whether there's a trial period or not. If there is a trial period, it's putting you, I suppose, at risk of being terminated within the first 90 days of your employment, basically with no rhyme or reason and no process needing to be followed. So literally the employer can just call you up on the 89th day and say, terribly sorry, Alison, we don't want to employ you anymore. Here's your notice, which will probably be a very short period of notice, maybe a week. And terribly sorry, it hasn't worked out. That's us. And I will then have no recourse. I'll have no ability to raise a personal grievance. I won't have any ability to challenge that dismissal or to stop that dismissal from happening. So a trial period is a really big deal. And it's something that if you see one in your employment agreement, some alarm bells should really be ringing. And ideally, you will ask your employer to take that, or your about to be employer, to take that out of the agreement. Employers often kind of just try it on and pop a trial period in there and hope that maybe people won't read it. So it's not necessarily going to be a really inflammatory thing to do to ask to have the trial period removed. So it's definitely worth thinking about that. As Matt said, an employment agreement should cover off your leave entitlements. So it should have all the stuff about annual leave and public holidays and so forth. It should also have a clause about sick leave. So how much sick leave you get. And when, in what circumstances you can take that sick leave. And we'll actually talk a little bit about sick leave in a moment. Some other things that you might want to have a look at will be whether there's an ability for the employer to require you to be medically assessed. It's worth having a look at that and seeing in what circumstances the employer can make that request and whether the employer can dictate who you are medically assessed by, whether they will pay for it, what use they will make of that information, and how far any sort of medical assessment will go. If you, I guess you run the risk in an employment agreement of giving your employer a kind of blank check to require a medical assessment at any time from any person for any reason, and it can be something that could actually be a real problem down the track. So it's worthwhile having a look at that clause and just reading it carefully to see what circumstances apply there. And the other clause that you want to have a look at is whether there's an ability to terminate for medical incapacity, or what's sometimes called medical retirement. So where somebody becomes too sick or too physically unable or psychologically unable to do the job, the employer might have the ability to terminate the employment in those circumstances. We quite often see clauses where if a person's away from work for a particular period of time, or they've had a certain number of sick days within a certain period, the employer will reserve for itself the right to terminate the employment relationship. That's not always going to fly. No, not always going to fly, not always going to get past the legal test. But it is something to be aware of in the employment agreement.
And we discuss it a little bit more at the end of the slide as well, around how that process works and what it might look like.
Yeah. The other thing that I just put at the end there is about kind of warranties and declarations. Often at the end of the employment agreement, or sometimes at the beginning, different employers put it in different places. There'll be a clause that says something along the lines of, I, Alison Maelzer, hereby declare that I have told my employer everything about me, and I've disclosed all my medical conditions, and I have disclosed everything about me that the employer might ever want to know. And it'll be something hugely broad like that, which if I sign up to that, and then the employer finds something that I haven't in fact disclosed, then they will slam me and say, "Oi, Alison, you have not told us the truth. You have misrepresented the situation. You haven't told us all about these things that you've said that you've told us about." Linking back to what we talked about earlier, though, the employer can't ask me to tell them everything about all of my medical conditions, because frankly it's none of my employer's business, unless those medical conditions do have an impact on my ability to do the job. So the fact that I had my appendix removed when I was 10 is not something that I need to declare to my employer, because it's not going to make a blind bit of difference to them. It's not going to have any impact on my ability to do my job. If, however, I'd been diagnosed with depression and that was going to impact my ability to get to work on a regular basis, or to be able to carry out the functions of my job, then that would be something that I'd be required to tell my employer about. Sick leave, do you want to talk about that?
Might as well.
Yeah.
So, as many of you hopefully might be aware of, sick leave has recently increased in the last couple of years to 10 days per year after 6 months. And that's not prorated if you're a part-time worker or a full-time worker, or somewhere in between. Every employee gets those 10 days. And we often get asked, what about those first 6 months? An employer may want to give you those in advance, and sometimes that is quite the case, but they are not required to. So they can ask you to take unpaid sick leave if you're too unwell to perform your job, and that is something that you have to accept. But it generally is something that you might want to have a discussion with. Generally, sick leave is for when you or a person who depends on you for care is sick or injured, as the title suggests. We find that sometimes picking up a child because their normal nanny or their carer or whoever is was also sick, and goes some type up the chain. That's not really what sick leave is for. It should generally be because you are either too sick or someone that you care for is sick and you need to care for them.
So one of the situations that we had recently was when the primary schools were on strike, or the teachers rather were on strike, and kids were at home. A lot of parents were asking to take sick leave. That's not the circumstance when sick leave should really be used. It's not a situation where either the parent or the child is sick or injured. So it's not really a situation when sick leave can be used.
In regards to proof or asking for a medical certificate, for example, if that is sickness or injury, generally what is required and what is provided for under the legislation is that if the employee is away for 3 days or more, it is for the employee to pay for the proof of sickness, most likely a medical certificate. And if it is fewer than 3 days, it is the employer's responsibility to pay for whatever the proof that is required. We also get asked a little bit whether attending regular medical treatments or attending a dentist appointment is covered under sick leave. And that will really depend on the circumstances, but it's not guaranteed. If you are receiving regular treatment because of a sickness, illness, or a disability, it is most likely going to be covered by sick leave, but that generally will just involve a discussion with your employer. Another thing that we often get asked is, well, I came in for the morning and then I kind of deteriorated and then I was a little bit too sick to work in the afternoon. So I only took a half day. Can I take a half day of sick leave, or does it count as full 1 day? And the starting point is that the legislation provides for full days. So there is no such thing as a half day. But in reality, a lot of payroll systems are set up for either in hours or half a days. So it's a case where it might even be in the employment agreement, it might say that you can take half days of sick leave. Because there's an acknowledgement that most people, if they can try work for the morning, they shouldn't necessarily be penalised for that. But again, it will also depend on your employment agreement as well. And we also see that sometimes employers will have unlimited sick leave or more sick leave than what is required to them by the legislation. So again, as if it depends is our favourite answer. Check your employment agreement is probably our second answer. Going to that document will help you work out what you have in terms of your leave entitlements.
Flexible work arrangements. This is something that doesn't get used nearly as often as it should, in my view. It's actually a really cool kind of section of the Act. What it provides for is the ability for an employee to make a kind of formal request of their employer for flexible working arrangements. And flexible work arrangements could be around the hours of work that you work, including the times that you work. It could be around the days that you work, whether that be which days of the week you work or how many days you work. And it can be around the place of work. So whether you are required to be in the office or in the workplace, or whether you're able to work remotely, be that from home. Obviously, there's been real advances in the ability for people to work from home. So the request, you can make a request at any time. It used to be that you had to have a reason to do with caring for children. I think at one point it was quite restrictive. Now you can make a reason for any reason, a request for any reason at any time, as often as you like. So you can spam your employer with request after request. It'll probably get annoying after a while. The request needs to be in writing. It needs to contain certain information, including, and slightly annoyingly, that you are making this request as a formal request, and you're making this request under Part 6AA of the Employment Relations Act. So the request then sets out like what flexibility you're asking for. So, hey, Hesketh Henry, I find that I'm getting really fatigued as I go through the day. It would work better for me if I started work at 7 a.m. and finished at 3 p.m. I'm asking for this to be a permanent variation to my employment. So you need to say whether it's going to be for a permanent ongoing situation or whether it's going to be for a temporary period. And actually, I'd like the flexibility, please, Hesketh Henry, to be able to work from home on Mondays, Wednesdays, and Fridays, please. So I make that request. I put it in writing. I give it to my employer. The employer needs to respond as soon as it possibly can, but certainly within a month of receiving the request. And there's limited grounds that the employer can refuse my request on. So they're all set out in the Act. And it's really if it's going to be an operational problem for the employer that they're going to be able to decline that. I guess what you can do to try and avoid that declining happening is to have a look at the reasons why they can decline a request and to try and meet those, I guess, in your request for flexibility. So if one of the issues or one of the reasons that an employer can decline is that they're not going to be able to get staff to cover the time that I'm not at work, I might think to myself, okay, well, I can probably fix that by asking my mate at work to cover for me at those times. And then in my request, I can say, Sarah has agreed to work later in the evening to cover the time that I'm not at work. And that'll really hopefully fix what could possibly be a problem and make it more likely that your request is going to be accepted. Was there anything you wanted to add to that, Matt?
Yeah, I guess another thing is, while we're looking, is we found that there's some really cool guideline resources on the Employment New Zealand website, which has a whole bunch of really cool and free resources. So if you just Google Employment New Zealand Flexible Working Arrangement Guide, there is some really handy checklists in there to help you work through it. But I guess the idea is that this mechanism shouldn't be a scary one. It shouldn't, although it is formal and it's in writing, and you may have to frustratingly sort of label it a certain type of request under a certain piece of legislation. The idea is that it can really just spark a conversation with your employer. So you can even see things if your employer is slightly hesitant, you can even agree to do something like a trial to see if it works, at least for the first month. For example, and after a month you check in and see if it is working or how you can tailor it. And as well as the request is sort of only sort of limited, I guess, by your imagination. For example,
some really cool stuff in here,
if for example, you wanted to take frequent breaks because you find that you're getting tired easily, instead of having one massive lunch break in the middle of your day, you have small 10-15 minute breaks every 2 hours, so you can grab a little snack, grab a little water, maybe rest your eyes away from the computer screen. Or for example, you know that you generally have a medical appointment in your mornings or your afternoon. You can have what we call core hours. So for example, from 10 till 2, you know you'll 100% be available and in the office. But for example, in those sort of shoulder hours, you might be working from home, or you might be off on a Tuesday afternoon, but they know you're going to time bank essentially certain other hours. So just sort of flicking through that guideline, which again is just on the employment government website, the flexible working arrangement guidelines. There's some really cool tips in there that kind of gives you
really good ideas.
Some ideas, some keywords, for example, as well as some checklists to go through, because I'm aware it can be, when we start quoting pieces and parts of legislation, I automatically saturate over this is my job, so I can understand it can be a little bit scary, but there are some really cool resources around, and I think people just don't know about it.
Yeah.
And that's why we don't see it as much. it should be.
It's also got kind of template requests on this employment.gov.nz website as well. So it sort of lays out what a flexible work arrangement request might look like and gives you the guidance of the bits to fill in. So definitely worth having a wee look at. We might as well make use of our tax dollars, right?
And I think it's also worth noting that if you have started a flexible working arrangement and it isn't working for you, then it's actually okay to speak up again and say, actually, while I thought this was what I needed, it's not quite, and can we tailor it slightly? So don't feel like you have to be locked in and have buyer's remorse, for sure.
Yeah. Employees' remorse. Yeah. Right. Health and Safety at Work Act. We'll just have like a really quick squiz at this. The idea with the Health and Safety at Work Act is that a PCBU, which is a person conducting a business or undertaking, so basically anyone running a business, needs to ensure, so far as is reasonably practicable, the safety of its workers. So reasonably practicable is a really high test. It's basically everything that you can possibly do to try and keep people safe. When you take into account the risks and the ability of the employer to actually deal with those risks. Cost is only supposed to be considered right at the end of all the other factors. So first you look at how dangerous the thing is, you look at how likely that bad thing is to happen, you look at what means there are to try and prevent the bad thing from happening, and only after you've done all of those things are you able to look at how expensive it might be for the PCBU to take that action. And only if it's wildly out of proportion to the risk will you be able to say, as a PCBU, actually, sorry, no, we can't afford that. So you're not expected to spend billions of dollars to stop somebody getting a paper cut, but if it's a serious risk that could really hurt somebody, then you are expected to spend basically what it costs to make sure that that doesn't happen. There's also sort of more detailed requirements in the Health and Safety at Work Act that talk about the work environment, the stuff in the work environment, so the plant and the machinery and what have you. The systems of work need to all be safe. There's an obligation on PCBUs to provide information, instruction and supervision. So you can't just like randomly leave employees to do their own stuff. You need to actually make sure that they know what they're doing before they expose themselves to risks. And they need to make sure, PCBUs need to make sure that people's health is monitored to stop people getting sicker or to stop people getting sick from the work that they're doing. Like I say, it's a really kind of onerous obligation on PCBUs, and employers are within that. Yeah, that's about all I have to say about that, really.
I also think it's important to note that you as an employee also have obligations as well. So you as a worker, not just an employee, but as a worker, may have responsibilities to follow the health and safety guidance. If you see risks, to speak up and all those sorts of, I guess, being a good worker and all that, you can kind of pass your mind to ensuring that you're wearing proper safety PPE gear and all those type of things to make sure that you're helping your employer meet their obligations as well. So it's not just completely on them, it is a slight two-way street.
No, the idea with the Health and Safety at Work Act is that everyone has responsibilities and you're all supposed to work together to make sure that that people don't get hurt from the work that they do. I guess in practice, just some of the things that you might want to have a think about. The idea with the Health and Safety at Work Act is that the employer or the PCBU needs to assess the risks, ideally eliminate those risks. If that's not possible, then they need to try and minimise those risks and the likelihood of it actually injuring somebody. Workplace risk assessment, so employers need to be checking on the hazards within their workplace. I mean, sometimes it's kind of big ticket stuff like that machine doesn't have a guard and I might get my hand stuck in it and that would be a big problem. Other times it might be kind of things that you won't necessarily, or employers might not necessarily see as being a major risk, but can actually cause people injury and illness, and are likely, in fact, to happen more often. So people getting their hands stuck in a machine, thankfully, doesn't happen that often. People getting eye strain and headaches from VDUs that are set up in an unhelpful way, or light in an office environment which is shining into people's eyes, people getting occupational overuse syndrome from using a keyboard or a mouse that isn't set up for them. Those types of things happen all the time. So while they might not be as dramatic as somebody getting their hand caught in a machine, they're actually something that is causing people injury and something that needs to be dealt with by a PCBU.
And we're also seeing more and more common people like occupational therapists coming into an office work environment and doing sort of a workstation assessment. So if, for example, you are concerned that the office setup that you have either in the office or at home isn't quite meeting your health and safety needs, for example, your desk is not at the right height, your chair is not ergonomic, or it doesn't have a back, for example, or it's quite hard. Your keyboard is very small, your mouse is really stiff. Those type of equipments are making sure that it's meeting whatever your health and safety requirements and your health and safety needs are. An employer should be aware of them. So while we sometimes think, as Alison said, it's the big scary machines, it's the huge conveyor belts, health and safety is all the equipment that you use. It's every station that you're working at. So it can be both the big and the small.
Yeah, the other thing to remember as well is that it's not only physical safety that the Health and Safety at Work Act considers, it's psychological safety as well. So employers and PCBUs have an obligation to consider risks to people's mental health as well as to their physical health. So making sure that work is arranged and supervision and training is done in a way that will allow people to go home from work in a mentally healthy fashion is also part of the obligation.
And that's where things like fatigue as well will really play into cards. So if you know that you are getting fatigued throughout the afternoon, that is something that you should flag with your employer, because they should be taking steps to help you manage the fatigue and however that shows itself.
Yeah. Cool. Oh, incapacity. So two questions there. Firstly, who's paying for the workplace assessment? Generally speaking, I would expect the employer to be taking steps to assess risks within the workplace and to mitigate those risks. And I would count workstation assessments as being part of that process, a process of assessing what the risks are. So, hey, that desk is too short for you. Hey, that mouse isn't placed in the right place. That's information that, to be honest, most employers aren't actually going to know. I wouldn't know how to set up a desk in an ergonomic fashion. I might have to outsource that by paying for somebody to come and give me that advice. Yeah, that's probably all I've got to say about that. It is definitely within the employer's obligation, so I would expect the employer to pay for that.
And again, it will obviously depend on the resources of the employer.
That's true.
Your big corporate are generally going to be expected to provide all those equipment, have things like occupational therapists come into the workplace. Your smaller offices where you might be only employing 2 or 3 people, it might be seen as too prohibitive.
Yeah. And then there's also a question about the incapacity clause and whether that's included in a standard employment agreement. I'd probably say that, I'm going to say 60 to 80% of employment agreements would probably have some sort of incapacity clause, some ability to terminate employment where somebody is medically unable to carry out the tasks and the duties of their role. There's varying incapacity clauses. Some are wild, some are really, really onerous, some are complete blank checks for an employer to fire people any old how. So it can be a real mixed bag of clauses there. Our clause, obviously, that we draft is a lovely balanced clause that provides a little bit of flexibility for employers, while not, like I say, giving a blank check to employers to be able to just sort of terminate at will. Moving on to incapacity, probably, Matt. Yeah. So medical incapacity, kind of like we talked about before, is where an employee is not medically capable of the ongoing performance of their duties. And that can be in a couple of ways. It can be because somebody is taking a bunch of short or shorter periods of absence, so having essentially too much sick leave and not being able to maintain a consistent attendance record. Or it can be a situation where somebody is unable to work for a sustained period of time. So if they are experiencing, for example, a really bad flare-up of their MS symptoms and they're unable to work for a period of months, that might be a situation where an employer is considering whether they're able to hold the job open until the person is able to come back to work, or whether they're going to need to terminate their employment and hire somebody else to do that job. Now, the question of whether that's going to be okay or not, from a legal perspective, is another of those it depends, and it depends on all the circumstances type questions. It needs to be a decision that a reasonable employer could make in all the circumstances, and the process needs to be a fair process. There's no blanket kind of hard and fast rules as to how many days absence or what period of absence will entitle an employer to terminate employment for medical incapacity. It is going to depend on the particular job that the person does, the size of the employer, the reason for the absence, the likelihood that the person is going to be able to come back or not. I've seen people who have been off work for periods in excess of a year, and the employer has been happy to keep their job open for them until they're able to return to work. Equally, I've had employers who are wanting to terminate employment when somebody's been away for a couple of weeks. So there's no sort of set number of days that you can rely on, and the circumstances are going to be really, really important. If you're the CEO of a company and you're the only person who can do that job, it's probably going to be a situation where the period of time that you can be absent is going to be quite short. If you are working in a call centre and there are 20 people doing the same job as you, it might be quite possible for the employer to hold your job open for quite a considerable period of time.
And an employer is also sort of expected to kind of consider all the options. So things, for example, if you can't complete 100% of your job, if there's an ability for you to sort of do what we call light duties. So for example, if there's some paperwork that you can help out with or some type of administrative duties, and you don't have to be lifting all heavy boxes, and you can help out the employer that way, that is something that can be considered. As well as if you've still got leave left, that's going to be very difficult for an employer to justify a termination. For example, if you do still have sick leave or you still have annual leave available. So I'm aware that's not necessarily a clean answer. It's not 13 days if you're this one, but it is always going to be. And the idea is that an employer, when they're making this decision, should really be engaging with you, and it should be a process. So it's the idea is that they need to be proposing proposing a termination or proposing what their views are, and they should be giving you the opportunity with your medical practitioners to provide a prognosis or provide that medical information, because the law recognises that an employer is not someone who has a whole bunch of medical information.
Yeah, that's right. I mean, it's very, very difficult for an employer to kind of make a call about whether somebody is likely to be able to do particular duties of their job. And that's where getting some medical advice is really helpful, because there may be parts of the job that someone can do and parts of the job that they're going to struggle with. So it might be possible for the employer, instead of just firing someone, to actually adjust the job so that so maybe the hours are reduced, or the duties of the job are changed so that the person can actually continue in employment. And I guess that's what that process is designed to tease out. So if the employer says, hello, Alison, we have a problem here. This is the problem for the business. This is what we're thinking of doing. I've then got the opportunity to say, well, yeah, you're right. I can't do my whole job at the moment. I'm hoping to be able to do that again in a couple of months. I'm having this treatment, which is hopefully going to make a difference to me. I'm not able to work in the office, but I could actually work part-time from home. How about we do that for 3 months and then see how it goes? If the employer had just flicked me without having that conversation, they would have lost the opportunity to continue having me work in a part-time capacity. So that process is actually really, really important for both sides.
Exactly, and we often find that sometimes a process might start thinking that it might unfortunately end up in a termination, but through that open dialogue and that conversation, you can actually identify those reasonable alternatives. So I would think it's also a really good idea to sort of engage some type of maybe HR help if you know anyone through that, or engage an advocate or a lawyer, because unfortunately this process is quite familiar, so they can also help you identify some of those solutions or alternatives that might not be necessarily that might spring to mind straight away for people.
Right, but I sort of feel like we have bombarded you with information, and we've had some questions along the way, which has been great. I think we're probably reaching very much the end of our time. Nicola, how are we going?
Yes, it was a very full session, and we're now just after 8 o'clock.
Yeah.
But look, there's just a plethora of really wonderful gems of information. I'm sure everybody learnt a lot tonight. I certainly did. So I think now's probably a good time to wrap up, unless you've got anything else.
No, that's absolutely fine. Happy to wrap up. We've popped our contact details on the end of the presentation. So if anyone does have any questions, or Nicola, if you end up with people sending you questions, feel free to fire them through. As I said before, we will send through a copy of the PowerPoint, so that if you do want to refer back to it and say, oh, they said something about sick leave, what was that all about? They can go back to the slides and have a look at that. So yeah, thank you very much, everyone, for the opportunity. Thank you for sitting through it.
That's wonderful. Thank you so much, Alison and Matthew, and good evening, everybody. Thanks, everybody, for joining.
Kia ora. Thank you, everyone. Bye.
Bye. Bye.